Hey guys, welcome to this video. We have some great questions here about credit report disputes. So let's say you dispute one time and the credit bureaus do not fix it. Do you dispute again or do you sue them? And if you dispute again, let's say a second time, and then they fix it, do you give up your chance to sue based upon them messing up the first investigation? And how many times do you have to dispute before you can go from negligence under the Fair Credit Reporting Act to willfulness or wantonness? So this is from 451 Credit, and you can read his questions there. These are some great questions. So I'll give you some thoughts. There are no just absolute hard and fast rules, but let me try to answer as many of these as I can. If you dispute, it's a proper dispute, so you identify the errors, you're very specific in your dispute, and the bureaus do not fix it, you can definitely sue. Okay. Now, if you dispute again and then they fix it, you can still sue for the first investigation that was messed up. Because once they did a lousy investigation, whether that was just negligent, whether it's willful, wanton, reckless, whatever, that what we would call tort. So you have breach of contract, then you have a tort. That tort was completed right here in that first investigation. So you can sue. So statute of limitations starts to run. You can sue. Now, the fact that they fix it later doesn't undo your ability to sue. Now, I'll just say this. If I had a choice between disputing one time and suing, or disputing twice and they fix it on the second time and then I sue, I'd rather dispute it once and then sue them and then be able to show the real reason they fixed it is because we sued them. Okay. If we sue them a second time and they fix it, then even though it's an unfair argument, they'll try and suggest to the jury, well, why are they suing us? We did fix it. Well, yeah, it's like you ran over me today and then tomorrow you chose not to run over me. Well, that doesn't change what you did here. But just the perception is that maybe this will lower the value of your case if you dispute a second time and they fix it. Now, a whole bunch of variables. There are certainly cases where that's not true. And there is such a thing as momentum or inertia, however you want to think about it. If they refuse to fix it the first time, it's unlikely they fix it the second time. Okay, so this is sort of my rule of thumb. If we have time and there's no pressing need, then we may dispute it a second time. Or if we think, we didn't make it clear. But really my goal is on that first dispute for it to be so clear, so absolute simple that nobody can misunderstand this. And if they don't fix it, then we sue. Okay. So that's my typical approach is we're going to give them just this phenomenal dispute. And if they blow it, they refuse to fix it. I sued 3 credit bureaus today. One of them said, you know what? We are going to investigate your dispute. And then they just completely botched it. So they get sued. The second one said, you know what? We're going to investigate your dispute. And then they refused to investigate the most important one. Okay. The one that I was suing on today. Now, there were some other errors and they kind of did a halfway job there, but they blew the one that we put all the pages of attachments for. Just sort of crazy. And then the third one just refused to investigate anything at all. Okay. So when we make it so clear and they have every opportunity to fix it and they don't fix it, then my inclination is to sue right then. And even though that's only one dispute, I think we can show, at least in the right circumstance, this is reckless, this is willful. We get to those punitive damages. Now, it certainly is easier. I have a case right now where we probably have 8 sets of disputes that were all very clear, okay, and they did not fix things. Well, sure, that makes it easier to get to that willful or that punitive damage level. But one really, really good dispute in that they just completely ignore it, I mean, what they have to come in and say, uh, well, we were just negligent. We were just careless. Well, I mean, how were you careless? Like, you got the certified amount, you just refused to do anything, or you refused to investigate, or you did investigate, but you like made up things. Said like, well, we've investigated this one part that you dispute. I didn't dispute that part. I said the whole account goes away, and you just like picked one random section of the account to say this is what you just. No, it's not. So one dispute can get you to that punitive. It's normally a little bit harder. Okay, so you have to look at, well, what else do you have in the case, and what are the advantages and disadvantages of filing now or filing later. I would say if any doubt exists in your mind, do another dispute. Okay, and sometimes you can even put in there, hey, we've already disputed this. You messed it up. We're disputing it again. And we have taken this approach where we'll dispute it multiple times until the credit bureau say, we deem these to be frivolous. We've already investigated. We refuse to look at them again. Okay. So, like I said, there's no hard and fast rule. It kind of depends on, in my practice, sort of in my mind, we have certain types of cases. Hey, one dispute, then we sue. Other cases, we'll like to see several, 2 or 3 or 4 disputes before we sue. So you kind of have to get a feel for, what your clients want, what their timetable is, and that type of thing. So I hope that that's helpful. I think hopefully I answered the questions you had. If not, just let me know, and you guys have a good one. Okay, bye-bye.